Well, thank you all for coming here. As some of you know already, my name is Eric Nakano. I'm the staff attorney at the Civil Self-Help Center, and this is our first trial preparation for self-represented litigants class. I just want to remind everyone of a few things. First, there is no CLE credit for this presentation. It's designed for persons who are representing themselves, so there's no CLE credit. Also, the class is being recorded, so if you have anything really bizarre to ask, I'm happy to answer that for you after class, unless you want everybody watching this in the future to hear your question. And today's class really is just an overview of the entire process. We're not going to go into a lot of things in a great amount of detail because, truthfully, I could talk about this for about the next 6 hours and still not completely cover it. And, well, I don't know about you, but I want to go home before then. But we're going to try to cover all the basics. With that said, Kate over here was the staff librarian who is working on this with me, has been incredibly helpful, and she and the other librarians are going to be an incredible resource in helping you find additional materials to look up to prepare yourself after you're done today. So consider today just a starting point in your preparation for your case. We call this trial prep, but to be perfectly honest with you, most cases don't go to trial. The number of cases, it could be upwards of 90 some odd % that settle or otherwise resolved either through default or some other way without going to trial. A lot of times people assume that their case will settle, and a lot of attorneys have not gone through that many trials because most often, if you're successful, you manage to resolve everything before that final step. With that said, you should prepare every single case that you do, and hopefully if you're self-represented, you don't have too many of them, but you should assume that every case is going to trial and prepare for it as if it is going to go to trial. The idea is that if you prepare it as if you're going to settle it, you're not really going to be fully prepared if settlements fail, and you're going to not be able to put your strongest case forward when it comes to negotiations. If, on the other hand, you prepare for trial and you're trying to negotiate with the other side and it's clear you are ready to take this case to trial, you have all your ducks lined up, you are in the strongest negotiating place that you can be in your case. So always prepare it just like you are going to trial, even if it doesn't ultimately end up there. Now, when should you start to prepare your case for trial? Ideally, before you even file your case or respond. The very beginning. You should probably anticipate what is your case going to look like at the end. When you start your case, either with a complaint or you answer, every complaint and every answer has to have at least one cause of action in the complaint, and any defense also has elements that need to be proven. Each cause of action, there's a list of things that need to be proven, and these need to be alleged at the very beginning. So you're going to look this up hopefully when you just start your case, but where can you figure out what elements you need to prove? There are a couple of good sources. The first is going to be in some sort of practice guide. For example, legal encyclopedias such as CalJURS, California Forms of Pleading and Practice, California Causes of Action, California Affirmative Defenses. These are good for laying out elements, and these are all available down at the library, and the reference librarian can point you at them. Another good place is going to be by looking at jury instructions. Have any of you ever served on a jury before? No one? Okay. Yeah, I've always wanted to be on a jury, and I always get bumped for some reason. I've never been able to figure that out. Well, at the end of a jury trial, the judge gives all of the jurors a set of instructions. And these instructions will say something like, the plaintiff has alleged that the defendant has been negligent. To find, and then have a few more facts. To find that the defendant has been negligent, you must find that the defendant owed a duty to the plaintiff to, and then they will go and they will spell out each of the elements that need to be proven. Well, these jury instructions didn't come out of thin air. They actually come from a book, that's California Jury Instructions Civil, also known as CACI, CACI, and these are published on the Judicial Council's website, at www.courts.ca.gov, and we'll take a look at that in just a second. If you bring up that website, you're going to see the Judicial Council web page right there. There's a link for jury, for jury. Then there's a link for jury instructions, and then they're going to have two sets of them. They're going to have California Civil Jury Instructions, CACI, and Criminal Jury Instructions, CalCrim. You do not want the CalCrim. They do not apply at all in your civil case. But the civil jury instructions, you can download them. If you were to put them in a book, they're fairly, they'd be fairly hefty to print out. But as a PDF, they're free download. And when you look in the table of contents, they're going to have an index that's going to show jury instructions for pretty much anything that you can sue for and any defense that you can raise. And when you pull that up, you'll be able to see what you need to prove, and or what the other side needs to prove. So, and it'll be something like this. And if you do take your case to trial and you take it in front of a jury, you'll be seeing these again. Sorry. When you know what your elements are, you're going to want to list out your elements. Each thing that the other side needs to prove, each thing that you need to prove, and customize them a little bit to fit your case. And you're going to want to list them out in a chart, a spreadsheet, however you want that'll allow you to organize it. Next to the element that needs to be proven, you're going to want to identify what sort of evidence that you have. And, and also, this could be witnesses, it could be documents, but whatever it is, you're going to have your element, and the evidence that you have for it, and then any notes that you might have. It might look something like this. So for example, in a hypothetical motor vehicle case, where a person has a duty to operate their vehicle in a safe manner, which would include requiring them to stop at a red light. Well, we've got that element, persons who were witnesses to it, the evidence that was supported, and then any notes that you might have that will allow you to tell, to identify what else you might need to look for, what you might want to follow up on.